Hello, my name is John Milburn. I'd like to speak to you about undertakings. Solicitors will often provide undertakings to each other or perhaps to the court. Undertakings need to be taken very seriously indeed. Undertakings might be given by the solicitor or barrister or legal practitioner personally, or may be given by a member of staff. There are consequences which are very severe for a breach of undertaking. I'd like you to consider a document which is prepared by the Queensland Law Society Ethics Centre. It's entitled Guidance Statement Number 1, Undertakings. It was published originally on the 27th of February 2015. And in amongst the document, it provides for a number of things. Firstly, I'll provide you with a copy of that document. You should see that now. The guidance statement refers to the Australian Solicitors Conduct Rules, in particular Rule 4 and then Rule 6, which deals specifically with undertakings. A solicitor should make sure that any undertaking which is given is complied with in a timely and effective way, and should not seek an undertaking from another solicitor or employee that would require the cooperation of a third party. So the purpose of these rules is to ensure that the ethical obligations and issues are outlined in one document. As indicated, there are very serious consequences if the guidelines are not followed. So there are some principles that need to be followed, and there's a definition of what an undertaking is. Very importantly, once an undertaking has been given, it must be observed scrupulously, says the court, regardless of whether the undertaking was proffered in error or oversight, or irrespective of any change in circumstances, no matter how radical, and irrespective of any hardship to the legal practitioner. And that's a quote from Chief Justice Martin of the Western Australian Supreme Court, Court of Appeal, in Legal Profession Complaints Committee against Datata. It's 2012, WASCA 2014, Chief Justice Martin and 51. So an undertaking that might be given by the firm or an employed solicitor will bind the principal if the employee has the ostensible authority of the principal or the firm to give the undertaking. So the society, quite rightly, does not recommend that employees give undertakings, and that should be given by a principal if they're going to be given at all. Undertakings can be given to the court, and they're very important. And of course, these things can be subject to censure if there are any issues that arise. The courts will also ensure that these undertakings are complied with in a disciplinary way as well. Undertakings can be given by Undertakings can be given by a solicitor on behalf of a client as well. So just be very careful about the way in which you word the undertaking if you're going to give it. So obviously, I undertake, says the solicitor, will be an undertaking from the solicitor personally. If the undertaking is on behalf of a client, then that's an entirely different thing altogether. Okay, so please read that, and all the very best. Bye.